A lot of people speak bad about attorneys. Uh, Maybe they're right, maybe they're wrong. You use your discernment. And in using your discernment, put into consideration the fact that everything that you do and whoever it is you engage in any activity with, at some point there's always an ability for you to hold people liable. If you interface with parties who are British Accreditation Registry members and you don't create any type of situation where the other party can be held liable, then, well, you waived it. You can't blame them for that. If you are a contractor dealing with someone who you want to repair a house, and you know that contractor is going to contract with someone else, or if you're a homeowner dealing with someone who proposes a certain amount to you and you want to, sell your property, or if you are some type of, representative or some Fortune 500 company and you're interfacing with potential clients, there's always a paper trail dealing with what you do so you can show the intent of your interaction. If you fail to show the intent of your interaction, then, well, no one can be held liable. And when it comes to things of this nature, even in everyday life circumstance, outside of tribunals, courts, publicly or privately, evidence is important. So an attorney did you wrong. They gave you false hopes, spoke real sweet to you, acted as though they cared for you, and you bought it, you believed it. But at the end of the day, you're left wondering, wait, what happened? Wait, my life has changed for the worse. I've lost this much or that much. Now you're upset. The question is, did you make your intent very clear? You might think you did because you told them, okay, look, this is going on and this is what I want. Or you thought, oh, well, these people are good at what they do. They're attorneys, they're lawyers, they went to school for it. So I'm just going to hear what they have to say and just do what they have to say. Keep in mind, attorneys, everything they do when they speak with you is a negotiation. They're negotiating with you. Presumably, they're negotiating with you under the capacity that, or under the presumption that you have less capacity mentally, spiritually, intellectually, socioeconomically. And they approach you that way. Whether they are supposedly nice about it or whether they're supposedly mean about it. Depending on whether you're in a federal jurisdiction, Article 1 lets you know that Congress shall make no law respecting an establishment of religion. It begins by saying Congress shall make no law in the sense that it's a prohibitory law. First article, the First Amendment, which the first article of the amendment or the first Bill of Rights is prohibitory in nature. And it makes reference to the Congress because the Congress is the only body within the government that makes the law. Executive orders are not laws. Executive orders only apply to agencies and contractors, the executive departments, etc. Unless it's a statute at large, or a general act, or a general law, a public act, a public law, then it is not law. And so no one is obligated to it. So it says, Congress shall make no law respecting an establishment of religion, prohibiting the free exercise thereof, or abridging the freedom of speech, of the press, or the right of the people to peaceably to assemble and to petition the governments for the redress of grievance. Establishment of religion, or the free exercise thereof. If you look deep into your Bible, your Quran, whatever religious books, whatever religious texts, whatever religious oral teachings, because some spiritual systems are not written down. It's passed down orally and is memorized. Whatever it is, I guarantee you there's a part in there that tells you that the responsibilities of attorneys when it comes to dispute must not be used. The moment someone in any court or tribunal tries to tell you that your religious belief is irrelevant, and because of that, you have to use an attorney, they've trespassed in this substantive right. Secondly, the prohibition of the abridging of the freedom of speech. The moment someone tries to gag you and say you can't say anything unless you use an attorney, trespassing against your freedom of speech. The press is your ability to keep records, whether through video, audio, or written version. The moment someone tells you that you need a stenographer that's hired by our courts in order for whatever transcripts that you put in to be admissible, this is considering you've done it right, you've followed the rules of evidence, and that you've attested to the truthfulness of whatever transcript you put in without using an appointed or hired employee of the court. The moment they do this, they're abridging your right to press, your right to keep record, your right to basically associate yourself. The stenographer is an officer of the court, the judge, the acting judge is an officer of the court, the attorney in either end is an officer or officers of the court. Or the right to right of the people peaceably to assemble, and to petition the government for redress and grievance. You have the substantive right to petition. If your petition is something as simple as a move for dismissal or a certificate of innocence according to the state law, if someone has been wrongfully convicted, or whatever it is you're doing, whether it's a void judgment you're doing, whatever it is you put in the court, that is your petition. And your substantive right to redress of grievance. Redress is your remedy. If someone has been aggrieved, meaning you've been hurt, you've been damaged one way, you have the right to redress. If they're telling you you cannot do any of that unless you use an attorney, right off the bat right there, first article has been trespassed against in its totality. Fourth Amendment, the right of the people to be secured in persons, houses, papers, and effect against unreasonable searches and seizure, shall not be violated. People think seizure is just limited to arrests. Of course, when municipal police stops you, they have arrested you. You don't have to be in handcuffs for you to be arrested. Arrest just means to put into hold, to seize, to stop. People think the word seizure within the Constitution of the federal or your respective state levels, they think it is limited to arrests, dealing with police. Seizure deals with whenever anybody stops, arrests, or seizes your rights, which are incorporeal. Doesn't have to be a physical body. This seizure can be the seizure of any of these articles herein. And if you're stopped from being able to speak on your own or on behalf of your son, your daughter, your mother, they are seizing your substantive right to be secured in your persons, your papers, and effect. Remember, you have the right to redress and grievance. That's your papers right there. You have the right to be secured in that. When they're saying, well, an attorney has to put this in for you to be able to enforce it, they're trespassing on this. And oftentimes there are two ways an attorney can be put on you. Two main ways at law. One is if you hire one, or if you consent to one. Either by you looking for one voluntarily, or by court appointment. The court appointment, or the court appointed attorneys, are based on constructive law. Meaning at this point, they are construing whatever they want to do with you because you've been deemed to be incompetent. And they think they can get away with it, which sometimes they do with many people. So they just stick one of their friends and buddies on you. And they just get you along to ride along with it. And they make that money, make that commission, and get you a plea deal. And basically keep a record, a dossier of you basically being their subject. In Illinois, Section 9, lets you know the Bill of Rights, Section 9. No criminal prosecutions. The accused shall have the right to appear and defend in person and by counsel. You have the right to appear by counsel. It does not mandate it, does not prohibit it, but it tells you, hey, you have the right to do so. Meaning it's a choice. And counsels are usually anyone who you go to give you any type of confidence, someone you confide in regarding the matter, someone you just want to speak with regarding any matter or any situation, so you can get clarity. Attorneys love taking pride in the fact that, well, they're professionals, so they're the only ones that can give you legal advice. All right, fine. Go ahead. If that's what you say, then I'll take you up on it. Under one condition. When you look at what an attorney is, besides the etymology, which basically means to turn over, basically tells you an attorney is one authorized by another to act for him. Remember we mentioned briefly about one of the two main ways that attorneys can come into an equation at law. Not in chancery or equity, but at law. Two main ways is if you voluntarily seek one out by consent, or if one is appointed to you. So they have to be authorized by your consent or by court appointment. And even then, through court appointment, you still have to consent to it. And oftentimes the court appoints an attorney upon you because they deemed you not being able to hold them liable, or deemed you not knowing these. Because these are undisputable. It's clear in its face what the intent is. It clearly tells you. And if they know you're not clear about what this is, they will stick one on you. This is Ballantyne's 1916. And Bouvier's 6th edition lets you know that an attorney is one who acts for another by virtue of an appointment. There you go again. Power of appointment. Now there are different types of attorneys. The attorneys of various kinds. Attorney in fact. A person whom the authority of another, aka you. Even if it was appointed by the court has to prove that they have the power to construe your rights or to make that decision. Remember, you have the ability to make the decision to appear by counsel of your choice, to have the right of association as affirmed by the First Amendment of the United States Constitution. And then you have the right to be secured of your properties, papers, and effect. You have the right to redress some grievance without anyone stepping in as a middleman. The person to whom the authority of another, who is called the constituent, is by him lawfully delegated. This term is employed to designate a person who acts under special agency. This means a private contract. It's the moment they begin to represent you by your authority, they become your agent. What makes it special is the contract and agreement you sign. And then it goes as far as to say, or a special letter of attorney. Meaning the definition of what an attorney is, letting you know right off the bat, yeah, you have the power and you should often appoint them by putting things on paper. Don't just take it by word of mouth. If you create an implied trust, it can be construed one way or another. And given the fact that an attorney is originally an officer of the court doing business, an attorney is originally doing business as an officer of the court, but originally the fidelity is to a foreign corporation, which is in Great Britain, which is the Accreditation Registry, who, by way of colonization, are doing business here. Since that's their fidelity, you are secondary. They've already been hired by someone else and are doing business in conjunction with the state of, which is also a 14th Amendment citizen. And then by further doing business with the county of, which allows them to come in and do business within your local government and the subsequent courts that that local government has, or the subsequent tribunals that that local government has, the county courts, juvenile courts, traffic courts, all that trash. So they already have a long line and a long list of contractors that they first have loyalty to. Everything else is just a facade of looking cute. Everything else is just a facade of making you feel like something is being done to favor you. Remember, your feelings is irrelevant when it comes to pen and paper. Your feeling is irrelevant when it comes to law or the operation of law, or legal stuff. They don't give a fuck about how you feel. And your feelings should be thrown out of the window when you deal with things like this. Be firm, be straightforward, and be steadfast. But your feelings about what you think someone cares about your life, your problems, these attorneys don't care about it. They care about their previous contract that you're clueless to, their previous fidelity that you're clueless to, their financial interest that you're clueless to. Not the one that you're paying them or compensating them, but other ones that definitely exist. Your spiritual and intellectual capacity of staying in one position so that they can keep doing what they're doing. They have loyalty and fidelity to that first before you or your problem. Keep that in mind. So if you're going to hire an attorney, you are exercising this right to counsel, right to be secured in person's papers in effect. So if you do not put it on pen and paper, the terms and condition of what you want them to do, how you want them to do, and that if it's not met, that they are fired automatically. Then it will be construed as whatever it is they want. It tells you this term is employed to designate a person who acts under a special agency. They're acting as your agent under a contract. Or a special letter of attorney. They're acting as your agent under your contract. So that they are appointed in factum. They're acting as your agent based on your contract. For the deed is your contract, what you want them to do. Written down, your contract, or special act to be performed. They're acting as your agent under your contract. All this repetitive synonymous words is letting you know we're not saying do this, but normally this is what an attorney is supposed to be. By operation of law, you have the right to counsel, the right to be secured in your papers, persons in effect, the right to association, the right to religion, redress and grievance, right to keep your own record, right to freely speak. And because of that, I'm telling you, you should probably put this in pen and paper what you want. Then it goes on to say, but in a more extended sense, it includes all other agents employed in any business or to do any act or act impious for another. Remember when we were talking about a court-appointed attorney when they deemed you incompetent and that they can just roll over you? Well, that's what it is. Meaning, in all other cases, just secondarily, it includes all other agents employed, meaning not by you in this case, in any business, aka daily court affairs. You know, they wake up, they wash their ass, brush their teeth, and they're, motor transportation, put on the costume, put on the facade, and start playing the role of God. Over who? Over you, the everyday man and woman. Over the people. Who created this Constitution and grants the power of that position of trust? They begin to appoint other people called constructive trust, to do any act or to act in place of another, aka Child Protective Services. When you look at the heading of Child Protective Service cases in juvenile courts, they will put in the interest of. When you look at probate cases, they will put it in the interest of. The court has appointed them. Why? Because you've waived the right to do so. If you don't put it in pen and paper, and if you don't put the conditions, you waive all of this. You waive all of this. So you can come in all you want and talk about your rights, this and that. If you do not express it, you're just playing with your life. Goes on to say, all persons who are capable of acting for themselves, and even those who are disqualified from acting in their own capacity, aka you're considered to be mentally unstable. When you begin to talk about constitutions and you're not firm about it, or you really haven't done certain prerequisite research, such as putting their oath on record, such as getting the police report at a very, very early stage, such as putting their attorney credentials on a record, such as coming straight in by challenging personal subject matter or territorial jurisdiction. And then that's another thing in the sidebar. A lot of people just talking about you don't have jurisdiction, you don't have jurisdiction. There are different types of jurisdiction. There's venue, subject matter, and personal. If you just loosely come out and say that you don't have jurisdiction, they know right off the bat that, oh, you really don't, this is something you heard somewhere. Cool. Well, we're going to do a psychological evaluation on you, because we don't want to keep hearing this over and over. And then through that, they're going to come to the conclusion by hiring some of their other buddies in the medical field. They're going to do an evaluation through your consent, because they need you to sit up there or make this appointment with this man or woman and answer some questionnaires. And if you're silly enough to actually do that, guess what? They gained a sufficient understanding that you are an infant and that you're not of the proper age or the state of mind to enforce the Constitution. All persons who are capable of acting for themselves, and even those who are disqualified from acting in their own capacity, if they have sufficient understanding as infant of a proper age and fames converts, may act as an attorney of others. So an attorney will come to you if they have concluded based on a psychological evaluation that you don't have the mindset to do so. They even go as far as to define the definition of attorney as the form of his appointment by a letter of attorney. So tell me, even when attorneys propose a contract to you, do they show you that? Is there anywhere within that contract that does it say we're going to enforce the Bill of Rights within the Constitutions? Do they say that? If it's not there within those pages that you're signing, if they propose a contract to you, then you probably shouldn't enter into that contract. The attorney is bound to act with due diligence, meaning following the terms and conditions, after having accepted the employment. When you go apply for a job, you sign an application. Then they give you the employee manual. That employee manual is the terms and condition of what you're supposed to be doing at that work or not, and the fact that they can hire or fire you at will. They even tell you in the application, this is at will. We can fire you if you want to. Well, you add that same clause to the contracts you're creating with those attorneys. And if they present that to you, modify it right from black and white. Get a copy of that, take a picture of it, and then, tell them that you've modified it, and that's what you want from them. The attorney is bound to act with due diligence after having accepted the employment. You are employing them. But keep in mind, they've already been employed by about 6 or 5 or 4 different people before you. Those people are really giving them good monies and good benefits. And in the end, to render an account to his principal of the act which which I think this means to say which he has performed for him. So whatever you put down, you must let them know that they must report to you during a certain period of time or as needed to make sure that they've enforced due diligence in enforcing the conditions that they've accepted. If they don't do this, then you yourself are not following the foundational basics of what an attorney is supposed to do. Then it goes to say an attorney at law, the officer in a court of justice who is employed by a party in a cause to manage the same for him. For him. Meaning whatever it is you want is what they do. But if you don't know about this, then you can't bring this in. If your contract with an attorney does not say this, a lot of people say stay away from an attorney. Don't do this. Okay, I mean, cool, do that if you want. But the least you can do for yourself to help your cause or your intent of really getting out of that BS that you're in, just take these and put it into the contract, or just make reference to it that this is what you want them to do. And it's that simple. The quickest way to know whether an attorney is going to really work for you or not is based on this. Now, keep in mind there are different types of attorneys. Trial attorneys, constitutional attorney, juvenile attorney, all that trash. Whatever it is that they consider themselves as, just make reference to this. If they don't want to do this, then you should know you should probably be doing a 180-degree turn and just go the opposite way. And put on the record that you proposed that contract to them. Because at some point, if you decide to enforce your substantive right to not associate with them, it becomes an ego battle because, they're not used to people saying no or people shutting them down. So this is why I say your spiritual game must be strong. Certain things you can do that if someone tries to impose themselves on you forcefully, they get touched without being touched. But if you don't believe in those weird, spooky stuff, the least you can do is memorialize the circumstance. Record the circumstance that, hey, during this day and this time, I proposed this contract, or this man or woman who says they're an attorney acting at this partnership LLC attorney's office says they want to represent me for this amount, and then I modified the contract to saying that I want these Bill of Rights within the Constitution enforced, and then they said they can't. Because of that, I denied the contract. And then add that to the case itself. Just in case they want to come in, because they will do that. They just want to prove a point to you. It's an ego thing. Most of them, their state of mind fits something close to being a psychopath. I'm not saying they are, but their state of mind fits quite close to that. So they want to prove a point to you by getting over you. They're used to putting people face down, ass up. And every time they look at you, they don't expect you to be intelligent. No matter how they approach you. Not all attorneys are like that. You will find a couple of attorneys who actually care. But the preponderance of evidence in everyday circumstance does not show that. Nonetheless, bottom line is, bring your contracts into the equation. One thing that I've also noticed that most people try to do is, once they've realized, oh crap, they didn't really do what I think they were going to do. Most people didn't come straddling along during the appeal, during the late stages, after an order has been made against them, and they're going to say, well, hold on, wait a minute. There was an insufficient or ineffective advice or assistance of counsel. They want to bring that up as saying, well, everything should be thrown away. Throw it away. Don't do this because, well, my attorney didn't do what he was supposed to do. Well, is there an evidence that exists? No, there isn't, because you didn't put it in writing. Here's an example of someone claiming ineffective assistance of counsel with the intent of the order being thrown away. It goes, the record establishes, and by the way, this is the opposing party, who's also an attorney, responding to the guy who was screwed over, saying basically, hey, look, yeah, you can claim ineffective assistance of counsel, but that guy's really not obligated to you. And also the courts have ruled that all they have to do is just tell you what your rights are, and that's about the limitations. Because it's up to you to know what your rights are. And based on that, you enter into contract. If not, then oh well. So it goes on to say, the record establishes, and the petitioner does not dispute, that trial counsel informed petitioner of his right to testify, having discharged their duty by advising settler plaintiff that he had the right to testify on his own behalf. It was not objectively reasonable to advise petitioner that, in the view of the trial counsel, taking the stand was not an advisable tactical choice. Meaning, the attorney that this petitioner hired, that attorney told him, hey, don't speak up. It's all right. Don't worry, I got you. Don't take the witness stand. Don't present your information. Don't worry, it's okay. And now the petitioner is coming and saying, well, he told me not to testify, and so because of that, he wasn't effective in advising me of the right things. I trusted him because, he's a legal professional. They provide legal service, so he knew what he was doing. But I'm realizing, well, he didn't really effectively do what he was supposed to do as my counsel, because he told me not to testify, and I'm finding out this, it hurts me. Then the opposing attorney is saying, well, he did inform you of your right. Although he did blatantly told you not to testify, but he did inform you of your right, though. So it was your obligation and your liability to know your rights. I'll read that over. The record establishes, and petitioner does not dispute, meaning you're always supposed to object, you're always supposed to deny. The trial counsel informed petitioner of his right to testify, meaning he told him, hey, you have the right to do so. Then it goes, having discharged their duty by advising settler, meaning they've satisfied their obligation. This guy did not put in the terms and conditions. So it is presumed that all an attorney can do is not enforce your right for you, because it is up to you to enforce it. But since they're, legal counsels or legal professionals, all they can do is just give you legal advice. And when you hear the term legal advice, what they're basically saying, we're going to tell you what your right is, and that's about it. Everything else is based on what our primary loyalty is about. Not what you think, what you feel, or what you want to do. Having discharged their duty by advising petitioner that he had the right to testify on his own behalf. There you go. You don't have to use me. And I'm telling you this. It was not objectively unreasonable to advise petitioner that. Yeah, that is true. In view of trial counsel, taking the stand was not an advisable tactical choice, meaning that attorney also told him it's not advisable based on tactics of how this thing should go, meaning from the perspective of an attorney. You shouldn't take the stand, but you do have the right to, testify on your own behalf. AKA, they're double speaking. Nor does the petitioner explain how petitioner was prejudiced by the decision not to testify, meaning he failed to bring up conflict of interest. Meaning he failed to bring up the fact that, hey, there might have been a contract that we signed and he didn't meet the condition. So if an acting judges read this, just this little 4.5, 5 lines, this is enough. He or she does not even have to read all this other stuff going on. They already know, oh, so you don't even know what your rights are. You didn't present your contract. You didn't present your terms and conditions when interfacing in business with this attorney. And this attorney satisfied his or her burden of proof by telling you, hey, look, in case you didn't know, you have the right to do so. I can't trespass on it. But, since you're entering into this contract with me, I'll make this proposition by saying, hey, look, don't testify, don't speak on your behalf. And then they go as far as to make reference to the transcript. In the court's allocution of the defendant during trial, the court confirmed that Saleh, or petitioner, understood that he had the right to testify. The court, all right, do you understand, sire, that you have the right to take the stand and testify in your own defense? And they go through this facade just to make it seem like, hey, we're doing what's right. But even before that attorney came to you and told you, hey, don't testify, they've already discussed how they're going to chew you up and spit you out in the judge's chamber, on the phone, at a brunch, at a coffee, a little coffee get together in their own little yacht, that, hey, this is what I'm going to do, this is what I'm going to say, and, I'm going to convince him. I'm going to use negotiation tactics and hypnosis to kind of just, make him waive the right, and we just get this over with and just get another one in line. But we're just going to play along and make it look right. So the petitioner, having already been hypnotized by whoever it is he hired without his terms and condition and waiving his substantive right, he went and said yes. And then the court, aka the acting judge, said, and you have discussed with your attorneys whether you wish to testify in this case. Meaning they're setting you up by using a record against you to make it undisputable that you know what your rights are, and that there's no burden or liability on whoever it is that you've hired to enforce your right on your behalf. And then he goes on to say, yes. It goes on to say, so long as defense counsel has advised the defendant of his right to testify, defense counsel does not provide ineffective assistance by advocating, even in the strongest terms, that the defendant not exercise that right. Meaning they didn't compel him not to exercise it, so long as they informed it. Remember, they're legal service providers, right? So they advise him of his legal rights, and that's the limitation of their obligations. That is sufficient for their service. In his eyes, he's thinking sufficiency of counsel is to actually help him out. The sufficiency of counsel, as they deem, if you don't present your contract in that letter, is that they just have to advise you that you have a right. Miranda, basically that. And that's it. And they create that contract instead of you creating it. And so you cannot hold them liable. And then they go on to say, counsel has wide latitude. He or she has a wide latitude if you don't provide it, meaning you just gave them all the powers. You have to limit their power. You have to turn this wide latitude in making tactical decisions. You have to limit it by creating your contract as to the specific thing you want them to do. Counsel has wide latitude in making tactical decisions. And whereas here, such decisions are made after thorough investigation of law and fact, those decisions are virtually unchallengeable. You cannot challenge it because there's no ground for you to challenge it, because you haven't created any presumption that they're obligated to anything regarding you. Bottom line, if you want to hire an attorney, create your own contracts based on the Bill of Rights. If you're not doing that, then best of luck. When you go on to your state's criminal or civil procedure, for instance, at Illinois, Section 2-612 of Public Act 82-280. Subsection C tells you all defects in pleading, either in form, meaning their court forms or the procedures of how you're supposed to enforce certain things. You're supposed to put a notice of motion and then a motion separately, and then you're supposed to put an affidavit in support rather than just putting everything. You're supposed to put a memorandum, or you're supposed to send this to that party only and not send this, or whatever all that stuff is. Or substance, the law itself, Constitution. Not objected to in trial courts are waived. They constantly point out the fact that this guy, after entering into contract with that attorney, implied contract that he didn't create conditions, he did not dispute certain things. And if you don't dispute it, it is deemed to be waived. If you at any point see that something is wrong, so you already entered into a contract with an attorney in an implied manner, you didn't write it down, you didn't make it clear, you didn't add it to the record. Somewhere along the line, you realize, oh crap, something is going wrong. You better start speaking up. You better fire that attorney and begin to speak up. Because if you don't, and then make sure you put into the fact that, you know what, everything that's been done regarding this attorney is wrong, and that you don't want them to present your cause anymore. Or if you do under certain conditions, it's never too late. If you don't do that, you waived it. All defects in pleading that attorneys did for you or did not do that they were supposed to do, either in form or substance, that you did and you messed up, or that you did not do but you were supposed to do, but you did not object to it, you have waived it. And then, I think it's Rule 12. Yeah, Rule 12 of Federal Rules of Civic Procedure. Section H lets you know, a party waives any defense listed in Rule 12b by 1, omitting it from the motion in the circumstance described. Then if you don't bring up any affirmative defense that can cause them to dismiss your case, you waived it. It's really just that simple. If you don't bring it up, you have waived it. And keep in mind, the moment you hire that attorney without bringing it up your terms of condition of what you need done, that attorney does things at their discretion. And they do with you what they want. But once again, if you're going to hire an attorney, best of luck.